All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
Welcome back to everyone. We will now proceed to hear from OPCV. 15 minutes, you have the floor.
Thank you, Madam President. Before I start, based on our team's counting, the legal representative used 65 minutes. So my question is, if I need just a few minutes more than 15 minutes, would it be possible for me just to use this time not spent by my colleagues?
We would prefer very much that we stick to the allotted time. There could be some flexibility if necessary, but please try and finish within the 15. Thank you.
Thank you, Madam President. And I will make my submissions in French. Madame la Présidente.
Your Honour, Your Honours, during my intervention I'm going to go into two different issues. Firstly, for the needs of the publicity of nature, I will give a summary of my submissions about reparations which I will propose for the victims in this case, with certain clarifications relating to my remarks. Secondly, I'm going to go into the issue relating to the eligibility of potential beneficiaries of reparations as direct victims of other crimes than the crime of persecution for which Mr. Al-Hassan was found guilty. Where it concerns my first theme, I represent 4 individuals who are in the first place victims of the crime under charge 6, which is the crime related to the the execution carried out without any prior judgment issued by a irregularly constituted tribunal. And these victims have suffered profound and multidimensional harm in short and long term. This includes physical suffering due to the detention and, for some of them, corporal punishment. In psychological terms, they had humiliation, anxiety, and emotional distress, which is lasting, as well as material harm due to the fact that the means of subsistence for victims and their family stability were disturbed, and because some of these victims had to abandon their place of residence, their place of usual residence. None of these victims was ever able to recover their level of life that they had before the commission of the crimes that affected them. The members and relatives of these victims suffered psychological harm, but also they suffered material harm because several of them were and still are financially dependent as direct victims. So the 4 victims that I represent have asked that reparations in their favour include measures to provide socio-economic support, financial payment to address their most urgent needs, as well as the needs for close members of their families, and furthermore support to undertake income generating activities to ensure their well-being and the means of lasting subsistence. And they also wish that reparations measures which are appropriate be accorded in order to establish as far as possible their social structure in the Timbuktu community as such. The elements of the case file show that the victims of crimes other than persecution, indirect and direct victims, they suffered harm which is similar. Of persecution, they also suffered collective traumatism. And that was linked to their religious group because the social structures, religious educational structures and other of the Timbuktu community were affected in a significant way by the crimes for which Mr. Al-Hassan was found guilty. The harm goes beyond the individuals, but it is for the Timbuktu community as such. The community of Timbuktu has suffered harm at a multidimensional level, such as community harm, economic harm, as well as transgenerational harm, which affects the coming generations. Taking into account the multiple harms that have been suffered by the victims, and in accordance with the wishes of the victims that I represent, I propose the type of reparations modalities as follows, that they be accorded to victims in the present case. Firstly, I would propose symbolic compensation of 600,000 West African francs to be accorded to each direct victims of crimes other than that of persecution. And this compensation would make it possible, firstly, to take up the most urgent needs of the victims, and it would also help to bear fruit for their family members. And this compensation has been calculated, given the court's practice in other cases, but also taking into account the principles of the establishment of amounts for compensation envisaged by the national reparations policy in Mali. I would insist that the compensation proposed must be considered as symbolic, and it must be complemented by additional reparations measures. Secondly, I would propose collective reparations with individualized components in the form of rehabilitation measures, medical measures, and socio-economic measures. They should be accorded to all the direct and indirect victims of other crimes than the crime of persecution. These proposals are inspired by the practice of the court in the Lubanga and Ntaganda cases. These reparations measures should include socio-economic support to make it possible for the victims to undertake income-generating activities according to the preferences of the victims. Thirdly, I would propose that there be collective reparations on a community basis, that they be accorded to the Timbuktu community as such, and to members of the population of Timbuktu, including the victims of the crime of persecution. This proposal is inspired by the practice of the court in the Ongwen case, according to which these reparations must include measures of collective rehabilitation. In the circumstances in the instant case, I would propose that collective reparations on a community basis should include two aspects. The first are community rehabilitation measures with a view to restoring as far as possible the social structures, the religious, educational and other structures as well of the Timbuktu community. The second aspect is the rehabilitation measures, which should make it possible collectively to provide this for large population groups. And on one side, psychological rehabilitation measures could take the form of collective psychological therapy, for example. On the other hand, rehabilitation or socio-economic rehabilitation measures should make it possible for the wider group of the population to collectively exercise income-generating activities. An option could, for example, be for associations or corporations in agriculture to receive funds. The Trust Fund for Victims, which has worked in Mali, could perhaps propose several activities in the form of projects which would reach large groups of the population. Now, this form of rehabilitation could also include professional training. And of course, none of the collective rehabilitation measures would be imposed on members of the population who do not wish to benefit therefrom. So the participation of victims in the project must be completely voluntary. Fourthly, I would also propose symbolic measures or measures of satisfaction, but such measures should be made in consultation with a wider group, as well as the chiefs and prominent persons and figures in these communities. When it comes to these possibilities, there's the expression of apologies by Mr. Al-Hassan. I shall make a few remarks about that point. I would already propose that there is a symbolic measure with a practical suggestion as well made by my clients, which goes towards the idea of restoring social cohesion, and this is the construction of one or two different meetings rooms or sports activity rooms where people could come together and, for example, if they want to have collective therapy, or if they want to undertake professional activities, or to discuss questions of common interest in such a multi-purpose arena or forum. And in the present case, it should be discreet, and it has to be inclusive and adapted to the reality experienced by the persons concerned, as well as taking into account their security situation in general and in the community of Timbuktu in particular. The implementation of these measures must in no case give rise to stigmatization of the beneficiaries, nor to tension or jealousy within the respective communities. I will go into further additional questions during the question and answer session. I shall now go on to my second theme, and in the written submissions of the defense of Mr. Al-Hassan, they argued that only the victims specifically cited in the judgment should be considered for the needs of reparations as direct victims as crimes other than that of persecution. And the fact of recognizing, for the purpose of recognition, the status of direct victims to other persons would harm the presumption of innocence on the part of Mr. Al-Hassan, Mr. Al-Hassan's presumption of innocence. And I respectfully submit that the number of direct victims of crimes concerned is, for reparations in this case, that should not be limited to victims specifically cited in the judgment. And this is for the following reasons. In the instant case, probably for strategic reasons, the prosecution has advanced within the framework of the presentation of its case a certain number of incidents which involved the victims, and demonstrating the criminal responsibility of Mr. Al-Hassan for crimes other than the crime of persecution. The Chamber has recognized the criminal responsibility of Mr. Al-Hassan for the crimes concerned on the basis of the present case, and also with regard to the incidents put forward by the prosecution. When doing so, the Chamber also determined the status of victims as individuals on the basis of the beyond reasonable doubt standard of evidence. I would remind everyone that Article 75 of the Rome Statute explicitly expresses the rights of victims to reparations for the harm suffered in the crimes for which the accused was found guilty. The standard of applicable proof for the determination of the eligibility of victims for reparations is that of the preponderance of probability, which is a lot lower than the standard of proof beyond all reasonable doubt. According to this standard of evidence, it only is required to demonstrate that that it is more probable than not that the persons concerned had suffered harm caused by one of the crimes for which the accused was found guilty. According to the practice of the court in the case, that the victim is not able to provide documentary evidence or other evidence during the reparations procedure, then a coherent statement from this person can suffice, such that they can be classified as benefiting from reparations. If the case put forward by the defense should be followed, that would mean, firstly, that the rights of victims for reparations announced by set out in the Rome Statute must entirely depend on the discretion or the strategic choice of the prosecution to move forward within the presentation of its case and to put forward certain incidents involving the victims and not to mention other incidents, as well as making its strategic cases to cite certain victims, to mention certain victims. And secondly, this would mean that the eligibility of victims for reparations should be determined within the framework of the judgment and according to the standard of proof by the standard of proof of the highest level, beyond reasonable doubt. I respectfully submit that this approach is quite simply that this cannot be used in terms of the reparations of the court, which provides that the eligibility of victims for reparations must be determined under the standard of proof, which is the preponderance of probability. Now, the defense case is no basis in light of the considerations of the chamber taken in the judgment relating to the mode of criminal responsibility of Mr. Al-Hassan for the commission of the crimes in question. The chamber has determined beyond all reasonable doubt the mode of criminal responsibility of Mr. Al-Hassan for the crimes concerned under Article 25(3)(d). And this is the mode of responsibility as a contribution by another means. And this type of contribution does not require a specific demonstration of that said contribution, unlike the requirements of paragraph A, B, C of the same article. The chamber has developed in detail a way in which Mr. Al-Hassan contributed to the crimes in question, given the following elements. Firstly, the Islamic police played a crucial role in assuring the implementation of the system of punishment and repression as set up by the Al-Sardin Hakim group throughout the Committee of Timbuktu during the period between April 2012 and 2013. And furthermore, Mr. Al-Hassan had no secondary position in that, but he played a crucial role and an important role within the Islamic police and the Ansar-Din group in general. Mr. Al-Hassan was one of the leaders of the Islamic police. He had an important role when it came to the implementation of repression and enforcement, when it came to the Ansar-Din group, when it came to the commission of crimes.
Je comprends que j'ai dépassé déjà.
I understand that I've already gone over. Can I just have 2 more minutes and then I can conclude?
Ok, parfait, merci.
Just 2 minutes. Thank you very much, Your Honour. So I'm not going to give other example because they're in the judgment and on the sentencing. But when it comes to the considerations of the chamber, when it comes to the judgment of on the sentence, and the measures were implemented, and for the crimes committed in Timbuktu in the time frame of 9 months. Now, according to the estimations from the Trust Fund for Victims, more than 1,210 persons were convicted without any trial or judgment by a regularly constituted trial, and more than 1,600 persons were detained, and more than 9,000 had corporal punishment inflicted on them under the standard of proof which is applicable at this stage and which has the preponderance of probability. It is most probable than not that a much higher number of victims than that given in the judgment suffered directly from harm caused by other crimes than the crime of persecution, and their eligibility for reparations should therefore be evaluated under these applicable standard at that stage and in accordance with the criteria of eligibility which should be established by the Chamber. To conclude, where it concerns the argument of the defence that there are more important elements when it comes to crimes other than the crime of persecution, which could harm Mr. Al-Hassan, and such people suffering from that are included, we should say that this has already been decided on a definitive way. The sentence has been set definitively, and the reparations before this court have no punitive effect for the person who is found guilty. The only objective of this procedure is to make it possible for victims to obtain reparations as far as possible for the harm that they have suffered. And by way of conclusion, I would respectfully ask the Chamber to set aside this line of reasoning of the defence, because if this approach is followed in this case, it could constitute an extremely dangerous precedent for the future with harmful effects for the reparation system before this court. Thank you very much. Thank you very much. Now, Mr. Duterte, for the prosecutor.
Mr. Dutel, thank you very much, Madam President. I'm going to try and get hold of the lectern, if I may, from my learned colleague.
Merci, Madame la Présidente.
Mr. Dutel, thank you, Madam President. Thank you, Your Honours. I shall try and stick to the allocated time, around 10 minutes rather than the 15 minutes. It is not customary for the prosecution to be involved in the reparations phase at the ICC. And Trial Chamber 2 in the Tukanda case ruled that the prosecution is not a party to the reparations phase. This primarily concerns the victims, of course. And the prosecution would therefore like to thank the Chamber for inviting it to this hearing today. Now, allow me to focus on a number of points. First, the women and girls of Timbuktu, whose courage during the demonstration in October 2012 is well established and commands respect and admiration. Mr. Al-Hassan, present here today, was found guilty of directly participating in the implementation of the policy of persecution carried out by Ansar Dine and Hakim, and of contributing on a daily basis to the campaign that was waged by Ansar Dine and Hakim against the civilian population for religious reasons. I'm not going to repeat the list that my colleague provided us with just now. So, it must be noted that women and girls were particularly affected by this religious persecution. In the judgment, the Chamber noted in paragraph 1570, and I'm going to quote in English,
specific rules and prohibitions imposed on women and their enforcement had a significant impact on all aspects of the life of women in Timbuktu. In fact, women feared going outside, drastically reducing their activities outside of the home. End of quote. De manière similaire, dans le jugement sur
in a similar manner, in paragraph 74 of the sentencing judgment, the Chamber also took care to specify, and I quote in English once again,
the restrictions imposed, notably on the appropriate clothing and the occupation of the public space, were implemented in such a way that they had a specific and disproportionate impact on females, members of the population of Timbuktu, who, in the circumstances, were in a position of particular vulnerability. End of quote. L'accusation note aussi
the prosecution also notes the gendered component of the harm suffered by women as a result of other crimes or the circumstances underlying other crimes for which Mr. Al-Hassan was convicted. I am, for example, referring to cases of flogging for adultery, or inter alia to a number of sanctions or measures that were imposed in marital matters, such as alleged insubordination. And I must say that the existence and the impact of the persecution of women by Ansar Dine and Hakim is not a coincidence. When one seeks to dominate and subjugate a population, a classic way of doing so is to target women. And this has an effect on men and society as a whole. And may I remind you of an item of evidence to illustrate this. In video MLI OTP -0011 -0376 at lines 97 to 100 of the corresponding transcript. And I quote that a gentleman from Timbuktu said, and I quote, "We no longer had any dignity. Our dignity was sold because when they beat a woman in front of you, or your wife in front of you, when they beat your sister in front of you, you can't say a thing. When they beat your mother and you can't say anything, it means that you no longer have any dignity." In any event, the prosecution submits that the Chamber must adopt a gender-inclusive approach and promote gender parity in all aspects of reparations. And I would imagine that the defense would not see any hurdle to such an approach. Because if we repair the damage suffered by women and restore part of their dignity, we also, in so doing, restore part of the dignity of the entire population. I heard this term or word dignity used by Maître Doumbia, and beyond financial and material issues, this moral dimension has all its value. I'm going to move on to my second point now, Madam President, Your Honours. And it is the question of the number of victims. In paragraph 74 of the judgment on sentence, the Chamber, and I quote in English, found
not only members of the population who opposed them, but also every member of the population who saw themselves forced to abide by rules and prohibition. Je passe quelques mots et je continue.
to move on a little bit and continue.
The number of victims of a crime of persecution is therefore very high. The entire population of the city of Timbuktu was targeted and was the subject of a deprivation of fundamental rights. Et à cet égard, l'accusation souhaite
And in this regard, the prosecution would like to underscore that we need to also take into account the members of the population who fled Timbuktu in order to escape religious persecution conducted by ACME and Ansar Dine. Because all of these individuals suffered moral and material harm when they left the city, of course. And you will be able to read in our submissions that one witness said that 30% of the population of Timbuktu, in his estimation, had fled the city. The third point that the prosecution would like to raise is the age of the victims, in accordance with Article 68, as well as the harm related to the age of the victims and their needs, in accordance with Rule 86. I am, for example, thinking of a certain elderly person who was a victim of Akim and Ansar Dine. I'm also thinking of P0565, who was approximately 14 years of age when she received 100 lashings in Timbuktu in 2012 in front of a crowd. In its reparations program, the court should take into account the specific needs of victims who were children at the time of the crimes. In so doing, they should bear in mind any long-term effects these crimes might have on their development. Reparations for minor victims should in particular cover lost opportunities for the future. And reparations should also include measures to prevent ostracism and discrimination against children, as well as promote their reintegration into society. Two final quick points, Madam President, Your Honours. The definition of the concept of harm, which must be interpreted broadly. Harm can be material, physical, or moral, and it does not necessarily have to be direct. There might be indirect victims as long as the harm is personal to them. Secondly, in this context, we should emphasize that the type of crimes for which Mr. Al-Hassan was convicted sometimes have transgenerational effects. And I am talking here about what our learned colleague from the OPCV talked about earlier. The marks left by whipping do not disappear on a father or a mother. Children and grandchildren can see these marks, and they cannot pretend that they haven't seen them. This factor needs to be taken into account as it is very important. any program, and we believe that the Chamber should take this into account. That is our submission. One last point. I'd like to belabor this point. In addition to individuals, there are also entities that have been affected by crimes of persecution. I am here thinking about schools that were closed or forced to apply the religious views of Ansar Din and Hakim. One witness said that around 150 schools were closed because they were not able to meet the conditions imposed by these groups. And here, there are, of course, long-term effects on the education of children who were affected. So, to conclude, Your Honour, reparations in the Al-Mahdi case are nearing completion. And it can be said that because of the combined efforts of all those involved, the LRVs and the Trust Fund. So now work is beginning on the Al-Hassan case. The LRVs have experience that will be invaluable to the Chamber because they have experience of the field, of the reality of Timbuktu, matters of security. I won't go into details here because, of course, security details are very important to the Chamber and very precious. Thank you very much. Presiding Judge, thank you very much, Mr. Duterte.
Trust Fund for Victims. 30 minutes, please.
Microphone, please. We cannot hear Council.
Can you try again, please? Can you? Perhaps you could use the row behind if it's working while we try and deal with the technical problem. Yeah, thank you very much, Ms. Ruiz Ventusa.
Thank you. Good morning.
Good morning. Please proceed.
Your Honors, I would like to first place on the record that our team composition at the Trust Fund for Victims has changed over the break. I am now present in the room. My name is Deborah Ruiz Verduzco. I'm the Executive Director, and my colleague, Veena Suresh, Associate Legal Officer, has also joined the team. The Trust Fund is honored by the opportunity of addressing the Chamber at this critical stage in the proceedings to deliver a set of observations by the TFV which complement our written submission. In these oral observations, I will cover three issues: the question of the chambers in relation to costs, a matter in relation to the principles of reparations, and other issues related to the implementation of an eventual reparation program. In relation to costs, in addressing this topic, the Trust Fund needs to be reminded of the current stage at which the proceedings are. This is the judicial reparation stage that will result in the issuance of a reparation order. This stage needs to look at both what has been destroyed by the crimes committed for which Mr. Al-Hassan was convicted for, as well as what has to be repaired. And when looking into addressing the matter of costs, we are naturally brought often into a bargaining process, because we are, of course, naturally compelled, the Trust Fund, and possibly you as well, on the tension between the principle of what it is and the reality of what can be. There needs a need to balance full recognition with feasibility. However, for this approach, the Trust Fund respectfully posits that if we are reminded at the moment at which we are, there is no need to engage in this bargaining. Today and in the current phase, the reparation order should recognize the harm suffered by the victims and consider the liability of the convicted person in relation to those victims. In the future, once the order is issued, in the next phase, the administrative implementation will begin, and practical considerations can inform better future decisions. Now, going into the matter of costs. Of course, drawing an estimate needs to be grounded on several assumptions for issues that are yet to be determined, both in the order and during implementation. That is, the judges have to determine the extent of the harm, the measures ordered, and the criteria and final or estimate number of eligible victims. In addition, certain costs might be further impacted by individual and specialized assessments of the victims' conditions themselves. For instance, medical assessments, treatment plans that will determine the scope of a medical intervention and that will, of course, also result in potentially different costs. But to move into this exercise in a productive and helpful way to the stage at which we are, we have ensured that we use certain assumptions and we make those assumptions explicit, therefore allowing the chambers to adjust our calculations to the extent that you finalize certain matters, especially when our assumptions might drastically change. As I will present the cost, my statements reflect summative amounts. Should the trial chamber require so, the detailed calculations that have led to these sums can be made available in writing. The key assumptions are that from the information that the Trust Fund obtained from relevant stakeholders, as well as through an ample study of victims' views that we have called the 2025 Victims' Voices Study, harm has been suffered by the community, by specific groups within the community affected particularly, and by a number of individuals in particular within that community. In relation to costs, therefore, we will address first the cost covering measures for the community, which is a category of victims in its own right. All parties have recognized that the crime of persecution has affected the entire population, collectively and communally. The Chamber itself has recognized this in its judgment decision of 26 June 2024. The harms may be considered to be moral, psychological, religious, and economic. The TFV collected information on some measures proposed by the members of the community, and these notions have informed the way we have gone about cost estimations. In relation to community, symbolic commemoration, and satisfaction measures, the community has given us some ideas. These include the inscription of the Moalid on the national and World Heritage lists, memorialization initiatives, and educational programs. The cost estimate for these measures is around 1.1 million euros. This calculation comprises 6 symbolic measures, valued each between 90,000 euros and 200,000 euros. For socioeconomic rehabilitation measures, the Trust Fund is informed by a community-based approach followed in the Almaty program, which comprises the selection, accompanying, and funding of micro and macroeconomic projects. Those projects are estimated between 300,000 euros each and 30,000 euros each for the micro ones. If we estimate that 4 macro projects can be implemented and 80 micro projects can be delivered, also focusing on particular communities affected, such as Christian minorities, certain professions that were prohibited or restricted during the occupation, or individuals who saw their fundamental freedoms violated or were forced to flee Timbuktu, then we can estimate that the socioeconomic measures at the community level could be valued at around 4 million euros. Finally, concerning the need of psychological rehabilitation, the Trust Fund recognizes that interventions are required across the community. In the Almaty program, the Trust Fund has implemented community-level psychosocial interventions. If we estimate to reach around 10,300 individuals, the cost of these measures would be 1.2 million euros. Together, all these community measures are estimated at around 6.3 million euros. These costs include costs that have been included and detailed as cost C in our written submission. Now, at the individual level, Your Honors, of course, the harm was suffered by individuals themselves. And the question is, how many individuals have suffered this harm? In our study, we understand that more than 9,000 individuals, 9,453 precisely, suffered severely, 8,849 moderately, and 9,563 mildly. There are also other similar numbers for severe economically affected, moderately affected, and mildly affected individuals at the individual level. If individual medical or psychological measures are implemented, the Trust Fund estimates that basic care will cost 150 euros at the minimum, up to 6,000 euros for major care. If you want to make the calculation, the numbers that are provided in the victim study by unit cost will allow to obtain a total amount. However, from a general calculation made by the Trust Fund, we estimate that only 10% of those affected severely have actually acute persistent harm. So that would be another approach for the Chamber to consider individualized measures. In relation to socioeconomic measures, the Trust Fund makes reference to programs implemented elsewhere where individuals receive between 350 euros and 850 euros in addition to training. With this cost in mind, the variation of individualized measures ranges from 21.3 million if the entire population of affected individuals is considered, or 3.9 million if only those affected severely with acute persistent harm are considered. That is 10% of the total population. Finally, in relation to compensation and individual awards, this is a matter that the Trust Fund did not address in its written submission. This can be, of course, awarded through individual or through collective awards as a modality of reparations. The Trust Fund has taken note of the submission of the parties, the amici curiae, and the prosecutor in relation to compensation or individual measures. There is a clear preference in their submissions for that compensation, for example, in the form of symbolic payments. The Trust Fund took note of today's submissions of the LRV to provide 350 euros to each victim, and of OPCV LRB proposed to get an orientation for such symbolic payments from the Malian National Policy on Reparations. In this regard, the TFV recalls that such policy provides for a comprehensive compensation scale for physical, psychological, and material damage, that a dedicated agency, the AGRV, has been created and is in the process of being operationalized. The amounts for compensation in this policy ranges from 900 euros to 5,500 euros for physical and psychological rehabilitation, and up to 7,300 euros for economic rehabilitation. These amounts would need to be extrapolated to the number of the victims the Chamber considers eligible. The Trust Fund, however, submits respectfully that in order to impose a compensation scheme as a modality for reparations, prior cases of trial chambers that have established prerequisites for compensation, including individualized assessment of harm, might be required. It is also important to consider that the application of the Malian National Policy on Reparations fall exclusively within the competence of the Malian authorities, and we caution the way that referencing or relying on this law may be relevant for purpose of estimates relevant to the application in the ICC. From a practical perspective, should victims receive compensation through the ICC, Malian authorities may request the court to share information on those individuals to ensure no double reparation. And measures would need to be put in place to facilitate or articulated and refined these principles across several cases. They represent an evolving body of law and practice that reflect legal thought and on-the-ground experience. These principles are not only our guiding standards, but they are also the benchmarks at which we measure our outcomes and we evaluate the success of implementation. They have been integrated into every activity we undertake, and we seek to pursue that the Chamber advances these principles on this occasion. And we respectfully submit 3 recommendations for the refinement of reparations principles. The first one, similar to the Ntaganda principle that implementation must be gender sensitive and inclusive, the Trust Fund proposes that it should also be conflict sensitive. Reparations should be designed with an awareness of prevailing tensions so as to not exacerbate them, but instead to ensure that they contribute to rebuilding trust and fostering coexistence. Secondly, participatory reparations. It is necessary that the principles go beyond the principle of consultation, a victim-centered approach, or accessibility. Instead, we believe that participatory approaches ensures that victims participate in the design, in the evaluation, and in the consultation of the way that reparations are implemented. Finally, the principle of adaptive prioritization. This is set out in paragraph 129 of our written observations that refers to the necessity of enabling and empowering the implementation phase to adapt to practical limitations as well as to preference of communities. This issue of principles leads me now to address the issues of implementation that we may face in the future. In this regard, I wish to make simply brief reference to important factors that are essential looking forward, but that are not necessarily pertinent at this point for the reparation order. The first one is the essential element of the order to be well known and understood by the communities, while also measures specifically addressed to individual victims be accompanied by confidentiality and other manners to protect the victims themselves. We will be certainly informed by the security context, which in the Almaty case has defined the way we adapt to manage tensions, access, and ensure access conditions, but that the security context has very much been informed by the level of cooperation that we have received from the Malian authorities themselves. Mali, as a state party that has also welcomed the physical presence of the court in its territory, has cooperated with the Trust Fund in the implementation of the reparations at the national level as well as at the local level, including through a steering committee that was established to oversee the implementation of these reparations. This brings me, of course, to the essentiality of the cooperation of Mali to the success of the reparations and of the order. The Trust Fund values the constructive engagement it has received, and we posit, Your Honors, that it could also be the Malian state could be encouraged to continue this cooperation. It is important to acknowledge the progress in relation to transitional justice that the Malian law provides, and the necessity for any future program of reparations to be implemented in a manner that strengthens the trust that individuals have on the Malian state, and that ensures that that implementation of the policy is catalyzed and further expanded. As a final point, Your Honors, I would like to emphasize as well that the Trust Fund would welcome any contribution that Mr. Al-Hassan could make economically, however modest, to meet his financial obligations under the reparation order. The evaluations that we have conducted on reparation programs show that any gesture by the convicted person, even a symbolic one, can have a significant effect on the value of any measure that the court may issue. For the victims to accept some gesture may take some time. And as researchers of the University of Edinburgh indicated in their amicus curiae, it often has a multiplier effect on the victim's satisfactions. Combined with a sincere and excessive apology, such a financial contribution has the potential of being deeply reparative. The Trust Fund anticipates the finalization of this phase of the proceedings. We remain prepared and ensuring our increased readiness to implement any program and any decision that you may deliver, as it will be certainly for the benefit of the court's legitimacy, of the victims, and of the trust in institutions that these measures can take. Thank you, Your Honors.
Thank you very much for those submissions. We will move now to the defense. Ms. Taylor, in the interest of efficiency and time, we have obtained the registry's cooperation to extend the session to 1:15 in the hope that the defense can complete their submissions. But if, appreciating you have 45 minutes, if there is any remaining remarks you wish to make after that, we can take a few minutes in the next session. That will leave us good time for a back and forth with the parties and participants in the final session. So if that's acceptable to you, we'll begin your submissions and we'll see how we proceed. Thank you. Ms. Taylor, you have the floor.
Microphone, please, Counsel.
Seem to have the same problem. It seems to be a front row problem today. Can we test? Can we test the middle section there with the front row? Don't seem to have anything. Can we try the second row there to see if that is working?
Test.
Perhaps, Counsel, you could just check and see if your microphone is working?
Hello? That works?
Yes.
Okay.
Yes, sorry, Ms. Taylor, we'll have to have the same adjustments to position.
Are you okay to do the same? I'll get my...
Please proceed, Ms. Taylor.
Is this working now? Thank you. I will be addressing the role of Mr. Al-Hassan in this process, and also the issue of how the victims are identified and defined in connection with Mr. Al-Hassan's conviction for persecution. My colleague, Maître Berlusier, will focus on proposed modalities to ensure a fair and efficient and non-discriminatory process. The defense has filed a table of authorities, and we will be referring to these authorities by number. We are also showing a document on the screen. It should be broadcast in public. While Mr. Al-Hassan is indigent, he would like to underscore his wish to contribute to this process to the best of his ability and in a way that is impactful. And there are 4 different ways by which he is seeking to repair the harm caused by his actions. The first is his public apologies. The second, through the assistance he provided voluntarily in identifying victims. The third concerns a financial contribution to the trust fund. And the fourth relates to his support for an efficient and effective reparations process which will be addressed by Maître Beaulieu-Lucier. Mr. Alassane issued 2 public voluntary apologies. The first on 17th of December 2024, and the second on 14th of April 2025. And they have both been widely disseminated in local languages. The April apology can now be seen in French on the screen. His apology was not intended to reduce his liability for reparations, and we're not asking that it do so. For some victims, it may be a form of satisfaction, for others it will not. Grief and suffering are personal, and they manifest differently for everyone. And that is why he ended his apology by emphasizing that the victims of Timbuktu have the right to both seek justice through the International Criminal Court's reparations process and to choose whether to accept my personal apology. These are not choices that need to be made against each other. If I may ask, is the document being shown?
Find it, Ms. Taylor.
Evidence Channel 1.
Thank you. I have a picture on Evidence Channel 1. I would suggest we continue, Ms. Taylor, and there seems to be a technical problem. Hopefully it can be resolved. Thank you.
Certainly. Certainly. The complexity of the events and the diversity of experiences in Timbuktu calls for a multi-pronged approach to reparations that accommodates diversity and difference. And we suggest that there's room within such a strategy to use Mr. Alassane's apologies to help repair the harm he caused and to prevent its recurrence. And we further propose that his apology may resonate with the following groups of persons. The first are the victims. The second are the other individuals who made wrong choices and whom he may now be able to influence in a positive manner. The third is the community of Timbuktu, whom he seeks to support the reparations process. As concerns the victims, Mr. Alassane has used a particular supplication which is derived from the Sayyid al-Istighfar. And he chose this language because the Prophet has decreed that it is the most powerful and genuine apology that a Muslim can use. And there are 3 key reasons why that is the case. First, it is anchored in faith. And that means to invoke it, you have to be truly repentant because you can't lie or pretend to God. As Mr. Alassane said in his sentencing statement, God sees into his heart and will know if his apology is from his heart or not. That's reference 2. Second, the supplication uses languages which juxtaposes the blessings received from God and the fact that the person has sinned. This shows that the person acknowledges their wrongdoing and shows repentance for having disappointed God. And third, the reference to keeping God's covenant is a pledge to God to never repeat the wrongdoing. And I refer to reference 3. So when Mr. Alassane apologized to all the victims he harmed, he made this apology from his heart, and he used the Sayyid al-Istighfar to emphasize his pledge before God to repair and never repeat this conduct. This is an apology built on Mr. Alassane's religious faith, but it is also addressed to all victims, irrespective of their faith. And that is why Mr. Alassane cited the Prophet's statement that not one of you truly believes until you wish for others that which you wish for yourself. This statement is an iteration of the principle of mutual respect for other people, other values, and other religions. Mr. Alhassan's religion is important to him, but he also understands that in the same way his beliefs are important to him, other people may have different beliefs which are equally important to them and equally deserving of respect and protection. And that's why he acknowledged in his public apology that it was wrong for the groups to impose foreign beliefs and ideology on the people of Timbuktu in 2012, and it was wrong for him to have been part of that. His public acknowledgement of wrongdoing and pledge before God of non-repetition are elements of the right to a holistic remedy. And since the community of Timbuktu has suffered from collective harm, it is significant that notable religious and community leaders have expressed their support for Mr. Alhassan's apology. And they have further suggested that it can play a positive role in local reconciliation processes. And I refer to the statements at authority number 4. This brings me to the second potential group whom Mr. Alhassan hoped to address with his apology. Mr. Alhassan shared his path towards recognizing the suffering experienced by victims in the hope that it is a journey that resonates with others and encourages them to embark on similar paths. And in so doing, he talked about what he suffered not to minimize or excuse the harm he caused, but to highlight the importance of looking beyond one's own pain and opening your eyes to the perspectives and suffering of others. And he hoped to demonstrate that if someone like him can reach this understanding, others can do so as well. When Mr. Alhassan came to the ICC, he had suffered from torture. He then lost a daughter. He was alone, afraid, closed off, and his religion saved him in his darkest time. And then the day of the conviction came, and the presiding judge clarified that this trial had nothing to do with either Sharia law or the Muslim religion in general. It's reference 5. The war crimes and crimes against humanity were not committed by Islam, nor were these crimes the necessary and foreseeable byproduct of Islam. They were the product of specific individuals and specific policies developed by individuals and applied by force. The victims were targeted because of their religious views, but they were targeted by individuals and not by Islam. And because Islam is a religion that values peace and reconciliation among peoples, that embraces justice and kindness, it was right for Mr. Alhassan to acknowledge his wrongdoing and seek forgiveness for the victims' suffering. And it's also the right thing for Muslims like him to state their opposition to acts that are not part of Islam, such as rape, forced marriage, or prohibition of work or education for women. And I refer to reference 6. And Mr. Alhassan hopes through his public declaration that others will also see that it's not too late to say sorry, that it's not too late to recognize and repair this harm, with a view to ensuring that all communities and all faiths in Timbuktu can live together in social cohesion, de vivre ensemble. And this brings me to the third group that Mr. Alhassan hoped would hear his apology, and that is the community of Timbuktu. Mr. Alhassan was found by this chamber to have been generally well liked by the population of Timbuktu. That's reference 7. He has now called on that population to support the reparations process. He's also asked them to support victims' right to access justice, irrespective as to whether they accept his apology or not. And Mr. Alhassan made this public statement to eliminate any potential stigma concerning the reparations process, or any perception that persons who viewed him favourably should not support this process or victims' rights. I'm turning now to Mr. Alassane second contribution to the reparations process, which is that he voluntarily shared information for the purpose of helping the registry locate and identify victims. And this information has now helped locate 6 previously unidentified victims, 2 of which are survivors. This in turn facilitated their right to access justice and the reparations process. And we respectfully submit that it's appropriate for the Chamber to refer to this voluntary assistance in the reparations order to highlight the importance of the right to truth and access to justice as core components of an holistic reparations process. The right to the truth and the related right to know the identity and location of victims are referred to as a form of satisfaction in the UN Basic Principles and Guidelines on the Right to a Remedy. That's reference 8. And an example of the application of these principles in restorative justice contexts can be found in Colombia's Special Jurisdiction for Peace, where perpetrators can volunteer to repair the harm by providing information that can help locate or identify victims. That's reference 9. And Mr. Alassane's actions are consistent with these principles and precedents. The individuals were publicly named in the judgment. There were therefore no protective measures. 3 were known to the defence, and the defence only took steps to identify the others after VPRS first confirmed that it had been unable to do so. So these were individuals who had not yet been identified by the registry and who might never have been identified if not for the voluntary assistance of Mr. Alassane. And Mr. Alassane has also expressed his willingness to assist VPRS in whichever way they deem helpful in relation to any other of the named 49 victims who have not yet been located. That's reference 10. And we submit that referencing this voluntary contribution in the reparations order would be helpful because first, Mr. Alassane's direct assistance is a very concrete indication of his support for this process and for the right of victims to come forward. And this is another action that can help eliminate stigma and promote security for the process. And second, it may also encourage other defendants in other cases to consider making similar contributions in support of the right to the truth. This brings me to the third contribution, which is that Mr. Alassane wishes to make a financial contribution to the Trust Fund for Victims, notwithstanding his indigency. To that end, he has proposed to save and contribute 164,000 CFR from his personal funds at the detention unit to be used as the Chamber deems most appropriate. This is the equivalent of about 17 weeks' income for Mr. Alassane and can cover the cost of a cow or sheep or a symbolic financial amount for direct victims. And we sought the opinion of the Trust Fund as to whether it would be more helpful to make an immediate voluntary contribution that is separate from the reparations order or one that is part satisfaction of the order. And the Trust Fund in turn indicated that if such funds are used against payment of the reparations order, and if approved, this would be the first time that this would happen in the history of court-ordered reparations at the ICC. As concerns the proposed allocation, Mr. Alassane suggested in our filing of 16th of July that his contribution could form part of a symbolic ceremony organised by the Trust Fund. For example, sheep could be distributed as food on the occasion of a festival such as Tabaski or Maulud, the Prophet's birthday. And the idea behind this was to show his support for the reparations process and to underscore the importance of respecting local beliefs concerning such festivals. And we're also aware that in previous cases, reparations orders have provided for symbolic amounts to be given to victims in recognition of the harm done and suffering caused. That's reference 13 and 14. We defer to the Chamber and Trust Fund as concerns how best to use such funds. I'm moving now to the more complex question concerning the number of direct victims, including for the crime of religious persecution. There seems to be general agreement that since the crime of persecution targeted the community of Timbuktu as such, the collective identity of Timbuktu suffered community harm which should be recognized and repaired. The defense also supports the position that community reparations should address intersectional forms of harm and prioritize vulnerable groups within that community. And we submit that the approach to independent trauma in the Tagunda Reparations Addendum provides a sound framework for recognizing and repairing harm caused by crimes which Mr. Alassane did not commit. And that's reference 15. In Ntaganda, the Chamber accepted expert evidence that past exposure to trauma can make victims more vulnerable to future suffering and can also aggravate the way they experience such suffering. So even though Mr. Lubanga was not responsible for pre-existing trauma caused by the armed conflict in the DRC, this pre-existing trauma was relevant to reparations because it informed or impacted the way the victims experienced the crimes committed by Lubanga. So in the case before you, Mr. Alassane was acquitted of all crimes concerning sexual and gender-based violence. Judge Akane further found that such crimes fell outside the common purpose, did not satisfy the chapeau elements of crimes against humanity, and also could not be considered as underlying acts of persecution. That's reference 16. Nonetheless, the fact that victims experienced sexual violence and gender-based crimes would have impacted the way they experienced the collective harm of persecution. There is therefore a basis for prioritizing schemes to repair such harm in any collective reparation schemes for persecution without imputing criminal responsibility to Mr. Al-Hassan. The same can also be said for historically discriminated segments of the community. And the notion of community may also include future generations impacted by harm. Children who died in infancy, those who were never born, the miscarriages caused by psychological stress or a lack of access to appropriate care. These are the points of agreement. Where there is disagreement is the question as to whether the fact that Timbuktu community suffered harm means that each member of that community can be considered as a direct victim in their own right. And it is our position that since Judge Akane's opinion is a reference point for the parameters of persecution, the verdict means that not every individual can be considered as a direct victim of persecution, and not every victim of persecution can be considered to be the victim of Mr. Al-Hassan. And while the trial judgment section on persecution refers to a majority of Judge Prost and Judge Mdua, this majority became the minority because of Judge Mdua's full acquittal by operation of duress. And as explained by Judge Akane, her opinion ultimately defines the scope of the conviction for persecution. That's reference 17. And in her opinion, Judge Akane set out two core limiting features on the crime of persecution. The first arose from the connection element, and the second, Mr. Alassane's personal liability. In terms of the connection element, Judge Akane found that under the Rome Statute, it's necessary to have a connection between the deprivation of rights and a specific crime. And she further found that this connection was only satisfied with a sufficient degree of specificity and notice, in connection with the criminal acts underpinning Mr. Alassane convictions in counts 1 to 5 and 14. That's reference 18. In practical terms, this means that the fact that someone was present in Timbuktu in 2012 and suffered from a severe deprivation of rights is not enough to make them a victim of the crime of persecution. And Judge Akane further restricted Mr. Alassane's responsibility for persecution to Article 25(3)(d). And while this mode of liability is not relevant to the quantum of his liability to repair harm, it is relevant to the scope of his convictions. And this is because the trial chamber expressly found that Article 25(3)(d) penalises contributions to specific crimes. And I quote, Article 25(3)(d) does not result in a reciprocal imputation of the acts of the member of the group. That's reference 19. Consequently, even though the group targeted the population of Timbuktu as a whole, Mr. Alassane's convictions under Article 25(3)(d) were based on specific incidents to which he was found to have made a culpable contribution. Now, the LRV have relied on Ongwen to claim that it's impossible to determine the number of victims at the time of judgment. That might be true for a case like Ongwen, where the defendant was convicted as an indirect perpetrator and bore individual responsibility for large-scale attacks involving multiple victims based not only on his actions but the actions of the group at large. But that's not the situation with this case. The Chamber was able to identify and list the incidents and victims related to Mr. Alassane's culpable contributions, and they did so in the annex to the judgment. And this means that the same direct victims, who are the victims of counts 1 to 5 and 14, also constitute the direct victims of the crime of persecution on religious grounds. The fact that the community of Timbuktu suffered collective harm also does not mean that its individual constituents obtain derivative, direct victim status. As explained in Katanga, collective reparations differ from individual reparations. The former confer on a group a benefit to which its individual members are not exclusively entitled, whereas in the case of the latter, the benefit belongs to each member of the group. It's reference 20. In the context of the current case, this means that if the victims are being repaired as a member of the community and not in their individual capacity, their participation in collective schemes will not extinguish their individual rights and their rights to be recognized as direct victims and to receive full reparations for such in future proceedings. Conversely, if the Chamber were to find that every member of Timbuktu community is in addition a direct victim, then this would result in a reparations order that includes direct victims who were expressly excluded from Mr. Alassane's conviction and sentence. And this is precisely the scenario that was addressed by the Appeals Chamber in the Lubanga Reparations Judgment of 3rd of March 2015 at paragraphs 212 to 2014. It's reference 21. And there, the Appeals Chamber explained that where a group of victims have suffered harm as a community, the reparations order should not be framed in such a way as to impute liability to the defendant for victims within this community who fall outside the scope of the conviction. In the context of this case, the trial chamber expressly recognized in the sentencing decision that Mr. Alassane's liability for persecution does not encompass victims of sexual violence or forced marriage, nor does it encompass crimes committed independently by Hezbollah. To describe such individuals as direct victims of Mr. Alassane would exceed the scope of his liability. Words matter. the words direct victims generate a public perception of guilt. And the settled case law of the ICC means that these words cannot be used in connection with the very crimes for which Mr. Alassane was acquitted. And we know and appreciate that this is not the outcome that's been suggested to you today. But this situation is not new. You would not be creating a precedent, you would be applying the established case law of this court as it has come up in every case that reached the reparations phase. And in every case, the judges explained that they cannot recognize direct victims outside the framework of the crimes expressly recognized in the judgment itself. And I refer to references 22, 23, 24, 25, and 26. As explained in Ntaganda, the ICC is a court of last resort bound by the principle of complementarity. It cannot assume responsibility for repairing the harm of all victims of all crimes. That's reference 27. And with due respect to the Victims' Council, the strategic choices of the prosecution do dictate the scope of ICC cases. And reparations is not the forum for rewriting the Rome Statute. And the role of the ICC as a court of last resort and a court which is not a human rights court writ large. Surveys cannot replace a sound evidential framework tied to convictions. We fully support the right of such individuals to be assisted by the Trust Fund's other assistance mandate. We fully support their right to participate in collective reparation schemes and for the specific experiences of collective suffering to be acknowledged and prioritised in such schemes. And my colleague Maître Berlier-Lucier will address that. And while we take no position on the definition of indirect victims, we note that this concept could capture the multifaceted forms of collective harm that existed in 2012. For those who stayed, those who fled, those who saw exactions on the street, and those who hid inside. Videos of punishments were circulated widely in Timbuktu and also refugee camps. And to limit this notion to those who witnessed the crimes in person would result in an arbitrary distinction between those who remained in Timbuktu and could freely circulate and those who could not. And we ask in turn that the Chamber pays special attention to the way it words its reparation order and the way it is framed so as to ensure that the public appearance and the public understanding of Mr. Alassane's responsibility is consistent with the limits set out in the trial judgment. Thank you. I will now turn to my colleague, Maître Berlier-Lucier.
Good morning. Bonjour, Madame la Présidente.
Good morning, Madam President. I have about 15 minutes to address the Chamber, the time remaining for the defence. Would you wish me to continue now or to restart after the break? I'm at your disposal.
I think that it's probably easier then if we take the break at this point, and then you can commence with your full 15 minutes, so as to not interrupt you in an awkward point in your submissions. And we can return and deal with the remaining submissions after the break. So we will recommence at 2:40, which would adhere to the hour-and-a-half break that is forecasted. I believe my calculations are right, unless someone corrects me on my math. Okay, thank you very much. We are adjourned until 2:40.
All rise, veuillez vous lever.